Okay, good afternoon. Welcome, everybody. My name is Jennifer Peel, and I am the director of the University of Washington's Center for Mental Health Policy and the Law, housed within the Department of Psychiatry at the University of Washington. And I am delighted to be moderating today's lecture in our lecture series on hot topics in mental health and law, civil commitment. The title of the talk today is Designated Crisis Responders and the Involuntary Treatment Act in Washington State. You'll be hearing from two experienced clinicians and DCRs, Dawn Macready-Santos and Laura Pippin. Before I turn the talk over to them, we do have some informational slides and housekeeping to take care of. So to start with, we want to recognize that the University of Washington, based in Seattle, acknowledges the Coast Salish peoples and the land which touches the shared waters of all tribes and bands within many nations. May we also honor their spirit and heritage while working for justice in these communities. If you'd like to identify the stewards of your land, we've listed a website here. We also acknowledge the unaddressed legacy of stolen labor and slavery, and we recognize the debt to exploited workers, past and present. This legacy remains and is currently something that we think about and acknowledge today. For those of you who are not familiar with our center, the Center for Mental Health Policy and the Law, we are housed within the Department of Psychiatry and Behavioral Sciences at the University of Washington's School of Medicine. Our center fosters integrative scholarship to advance empirical knowledge, training, research, and practice in forensic mental health. And it's our mission to address the most urgent issues arising at the interface of mental health and the law. Our center is organized around three pillars of excellence. These include education and training, research and policy, and service. These pillars are intended to facilitate interdisciplinary collaboration and innovation by removing barriers between researchers, policymakers, educators, and clinicians. Now, you may know that this is the third lecture in this series on hot topics in mental health and law, civil commitment. All of these sessions are being recorded, and you may watch them at a later time through our website. Also, I invite you to participate in future sessions. You will see that the last session in our series, that on June 10th, will be a panel discussion where we are re-inviting all of the speakers from the series, and it will allow us to ask more questions and answers and continue the discussion of this important topic. Now, recordings and continuing education matters. The recording and presentation slides will be made available on our website, and they should be there within a week. Certificates of attendance will be available for attendees who indicate an interest, and you can receive an email about that from our center. Continuing education is only available for attendees who attend this live Zoom session, not if you simply watch the recording. And in terms of continuing medical education, it's available for UW faculty and staff only through an email that you'll be able to receive through our center. But for non-UW learners, we will track your attendance via Zoom. So make sure that you do update your name on Zoom so that we can record you. Finally, some disclosures. Today's speakers, Dawn Macready-Santos and Laura Pippin, have no financial relationships in any ineligible company relevant to this presentation to disclose. One of the planners of this series, Dr. Kopelovich, she has a relevant relationship as a paid consultant to listen, but all financial relationships have been mitigated. None of the other planners have any other relevant financial relationships to disclose. Some additional logistics. It's important to recognize that the opinions expressed in the talk today are the views of the speakers and do not reflect the position of the center or the University of Washington. No official support or endorsement of the opinions described in this presentation come from the center or the UW or is intended to be such. Now, automatic captions are available, and so you can certainly click on the control toolbar and then click on the icon to access that. To submit questions, please use the Q&A function in Zoom. We hope to have some time at the end so that I will be fielding questions from the audience. We ask that at conclusion of the talk today, you complete an evaluation poll. And then as a reminder, the series will conclude with that panel discussion at our June session. Let me introduce you to our wonderful speakers. The center received many requests to give a talk on DCRs, designated crisis responders in our state, what they do and their involvement in the civil commitment process. So these two speakers have direct experience. Let me share a little bit about them. Dawn Macready-Santos, she is the co-president of the Washington Association of Designated Crisis Responders and has been a designated crisis responder in Clark County for 8 years. She's a licensed social worker at Oregon Health and Sciences University at the Institute for Intellectual and Developmental Disabilities. She has worked for 2 decades in the crisis and complex medical and mental health needs community in Washington and in Oregon. She has extensive experience coordinating services and navigating complex legal, medical, and court systems with individuals. Dawn routinely teaches professionals about involuntary commitment law. And our other speaker, Laura Pippin, is also the co-president of the Washington Association of Designated Crisis Responders and the program manager of crisis services in Central Washington. She has been a member of the Crisis Response Improvement Strategy Committee for the past 3 years. Laura has been designated crisis responder in Washington since 2012 and previously was a designated crisis responder in Oregon for over 20 years. She is invested in communities and individuals in Washington and advocating for their safety and quality of life. She holds a Master of Science in Psychology. As a reminder, to submit questions, please click on the Q&A icon in Zoom. Now with that, I'm going to turn it over to our wonderful speakers who I really appreciate being with us today.
Good afternoon, everybody. So today we're very excited to be sharing information about the role of designated crisis responders and the Involuntary Treatment Act in Washington State. We have a few specific objectives that we want to go over. We are hoping that you'll learn a little bit about the civil commitment process in Washington State, identify elements of assisted outpatient treatment practice in Washington State, and then we will also be discussing additional routes to civil commitment, including Joel's Law, Sheena's Law, and Ricky's Law, and we'll be kind of giving you information about those different laws. Some of the topics that will be covered today are Involuntary Treatment Act process, what is an ITA hold versus a commitment, substance use disorder versus mental health ITAs, assisted outpatient treatment practices in Washington State, LRA options in Washington State, and then again, Joel's Law, Sheena's Law, and Ricky's Law. So designated crisis responders in Washington State are specialized. We have to have a master's degree or higher as our credential. We have to be licensed by the Department of Health. And then we receive a bunch of specialized training around Washington State's Involuntary Treatment Act. DCRs are designated and provided with the authority to place an individual on an emergency behavioral health hold through the civil court system. Some of that training is pretty intensive. We have an DCR Academy training that's 40 hours long, so it's an entire week. Laura and I teach that. We also have several specialists that help teach at the Academy. It's very intensive. We really address all of the different areas. Any new DCRs are expected to attend this Academy so that they can get the most current information about ITA law in our state. Every county that individual DCRs work in also provides trainings to DCRs. So they're not just getting the training from us, from WADCR, but they're also getting all of that mental health training from their agencies. There's a yearly DCR conference for DCRs. This one's optional. They don't have to go, but we will usually provide a topic that's important for our DCRs. Like this year, we did suicide prevention. We also are required to have CEUs as part of our licensing. Like I, as an LICSW, have certain CEUs that I have to finish. And most of the different master's level clinicians will have CEUs uh, that are needed by their licensing boards. We also have ongoing meetings for DCR agency managers to make sure that everybody is up to date and kind of knows where the laws are currently and what's going on. And it's also just a chance for everybody around the state to kind of connect in terms of the managers. And then we also offer consultation to DCRs for ongoing technical questions. So that's can be very helpful for DCRs to just know that they can always reach out to us and get that assistance. So DCRs have to have certain expected education and training. So they need to understand psychopathology and psychopharmacology. They have to have knowledge of lifespan development because we work with people of all ages, psychotherapy, family crisis intervention, individual and family dynamics. We're looking at all of these things when we're working with an individual. Another really important thing that we have to have education and training in is crisis intervention assessment of risk. That's a big part of our job. And we have to be able to assess risks for people with both mental health disorders and substance use disorders. And obviously, a huge part of our risk assessment is suicide risk and looking at danger to others. We definitely need to have an understanding of how to assess for grave disability, health and safety, cognitive and volitional functions. We also have to have an understanding of special populations because a lot of the populations we're working with have dual diagnoses. So we'll have people with intellectual disability, we'll have people who have, you know, geriatric needs. We will work with people who are from different cultural populations. So we really have to have a good understanding of the diverse populations that live in our state. We also have to stay current on substance use disorders and also kind of what substances are being used currently, how that might impact our patients and our individuals. And then we also have to get training in adolescent mental health issues because not only do we see adults, but we see adolescents 13 and up as well. So it requires a lot of extra training and education for us.
So the tribal DCRs are part of the Washington Indian Behavioral Health Act 2020 and Washington Administrative Code 182-125-0100. They represent a partnership between tribes and the Healthcare Authority to offer culturally attuned care for tribal communities. And what the best practices for American Indian, Alaska Native individuals is if the individual is identified as an American Indian or Alaska Native, asked to determine the tribal affiliation, identify if there's a tribal crisis coordination plan in place, notify the tribal contact of the decision to detain or not to detain according to the protocols, and that contact is supposed to be made within 3 hours. Consult the guidance development to conduct culturally appropriate evaluations for American Indian and Alaska Natives, individuals published by the Healthcare Authority. And Lucy Mendoza is the individual at the Healthcare Authority that kind of helps navigate all this for the American Indian and Alaska Natives. For questions or concerns, contact the Tribal Coordination Hub or the Healthcare Authority. When to make a referral to a DCR. First, there is evidence that a referred person may suffer from a behavioral health disorder. Behavioral health disorder includes mental health or substance abuse. There is evidence that the person, as a result of a behavioral health disorder, presents a likelihood of serious harm to themselves, others, person's property, or the referred person may be gravely disabled. if the referred person refuses to seek appropriate treatment options.
So the next part we want to talk about are components of the ITA investigation. And the ITA investigation starts from the time that, the hospital calls us in to see the individual. When we're doing an ITA investigation, there are two parts. There's actually three parts. One part is the face-to-face evaluation. And during that face-to-face evaluation, we're going to be reading them their rights. We're going to be doing a mental status exam. And then we're also going to be discussing voluntary treatment, safety planning with the individual, least restrictive options. We, in general, want to try for the least restrictive options when we're meeting with individuals. We don't want to just automatically detain people. Another component of the ITA investigation is medical clearance. So if they're at a hospital, they would be getting medical clearance. There are times we're doing an ITA investigation in the community, like police will call us and we'll go out in the community and do an investigation. And at that time, we wouldn't have medical clearance. So we would then send the person to the hospital to get medical clearance. Another component of the investigation is going to be collateral information gathering. So it's really important that we're talking with all of the different people around this individual to gather information about what got them into this situation and what supports are available for them, and how can we help look at keeping them safe. When we're reading our rights to the patients, and we have to do this, and we really want to make sure that we're doing this right away before we talk with the individual. We don't want to use any information unless we've read them their rights first. And we really want to take this as an opportunity to explain in layman's terms to our individuals what their rights are, what our role is. We want them to actually understand why we're there, what our role is, and then also, are we part of the facility? Are we not part of the facility? And then we want to kind of describe, like, what is the timeline they can expect? How long are we looking at for a hold? And then we also provide information about legal counsel. And it's very important that we let our individuals know that they have a right not to talk with us. They have a right to have an attorney. They can remain silent or request an attorney. And if they say they don't want to talk with us and they would like an attorney, we are obligated to stop the interview. This does not mean, however, that we're going to stop the investigation, because obviously we still are on a timeline and we have to continue the investigation. When we're reading rights, we need to identify what our name is, our position, and what is going to happen as an outcome of this investigation. We might hold you for 120 hours. You might have then a court hearing. You'll have another court hearing to determine if we want to commit you. So letting them know all of these factors ahead of time really allows the individual to understand the process, letting them know that they have the right to remain silent, and also just letting them know that what we're talking about with them is going to be used as part of our investigation. And it's also going to be used to help us make a determination if they need to be detained or if we can safety plan, all of those things. And you want to make sure that they know that they can access an attorney. And then another very important thing that we include when we're reading the rights is letting them know that if they're going to be detained due to danger to self or others, that their firearm rights will be suspended for 6 months. And we have a form that we give them to let them know. So not only we're giving them this information verbally, but we're also giving them a copy of their rights. We're also giving them a copy of the firearm information so that they're fully aware when we're evaluating them about their rights. Another thing that we do during the ITA investigative process is a mental status exam. We need to look at how is the mental disorder or substance use impacting this person's mental status. What does their behavior look like? Are they, speaking quickly? Are they having a difficult time understanding us? Are they talking to unseen others? We want to look at what does their behavior look like. How is their judgment? Do you feel like you could safety plan with this individual and that they have good judgment? Or is this somebody that's so ill, they're not going to be able to have appropriate judgment? What does their presentation look like? Are they oriented? Do they know who the president is? Do they know what month it is? And we also want to look at orientation for other causes of um, disorientation, which could be, Alzheimer's or dementia. Like, we want to make sure that this is due to a mental illness. So orientation is one of those really important areas that we want to make sure is there. We want to look at their memory, their thought process, their affect, and then impulse control. If you're going to have somebody who is extremely impulsive and you're going to let them go home, you've got to make sure that you feel safe letting them go home, despite difficulties with impulse control. Or on the contrary, you should be holding them because you don't feel like they're going to be able to keep themselves safe due to poor impulse control. When we're evaluating an individual, we want to really make sure that we're using principles of trauma-informed care. A lot of the individuals that we are seeing in this system are victims of trauma. And so really making sure that we're paying attention to that. We also want to make sure that we have a good understanding of the individual's like developmental functioning. Is this person somebody with an intellectual disability? And do we need to make sure to break down the rights, so that they actually understand them at a third grade level. Also, cultural and ethnic beliefs. We need to make sure that, is this a person who comes from a culture where mental health is not necessarily something that is understood in the same way we understand it here? Do we have people in the family that are supportive of this individual who can help kind of bridge those cultural differences? We also want to make sure language spoken and communication is understandable for the individual. Like, if does this person need an interpreter? I will not do an assessment unless this person has an interpreter if they speak another language. We want to make sure that they're understanding what's going on. We're not detaining somebody just because they can't speak the language. And sometimes, hospitals don't always love that when we say we need an interpreter, but we have to have an interpreter. And if it's somebody who uses ASL, we need somebody who can use ASL with them. We also want to look at their history. Do they have past inpatient treatments? Do they have a prior diagnosis? Have they been stable for a long time? Or is this somebody that's kind of in and out of the hospital? And this is really important in substance use because we want to know, is this somebody who's coming to the ED 10 times a month because they're intoxicated? Or is this somebody who has schizophrenia but they're taking their medications and they're holding down a job? We want to make sure like we're really looking at the big picture with these individuals. We also want to kind of know, like, how long have these current mental health symptoms been going on? How intense are they? Um, how frequently are they happening? And then, really important, we want to look at any medical conditions or diagnoses. And this is something that's super important when we do get medical clearance. Do they have a UTI? Is there something medical going on? Are they in pain? Like, is there something else causing this deterioration? So that's where it's really important to work in collaboratively with the physicians to make sure that all of that is ruled out. Medical clearance is best practice. And again, we are a whole being and it's not just mental health or physical health, it's both together. So we want to make sure that they're getting a medical screening done through the ED or through the hospital. And these are, assessments that include labs. They're going to rule out medical conditions. The social worker, if there is one at the hospital, there is not always a social worker, but sometimes they'll do telehealth with a psychiatrist, or the doctor will do the mental status exam, but kind of gathering that information in the medical record. If this is a first-time psychosis, sometimes they'll do a CT scan. We always make sure that they're doing a drug test just to be able to know, is this person using substances? Is this a person that's not using substances? We want to make sure that all of the medical conditions are ruled out when we're detaining somebody, because when we send somebody to a mental health facility, that is not a hospital. It's not, it's not a medical facility. And so they're not going to get the medical treatment that they need. And so those facilities, if they see that a patient has untreated medical issues or medical issues that they can't care for in the hospital, they have a right to decline to accept the patient. And at that point, the patient will need to stay at the hospital until stabilized. And that can be hard for hospitals sometimes to understand, but just really helping them to understand that the difference between an inpatient facility and a medical hospital is so different, and we do want to make sure that those needs are being addressed.
So voluntary treatment, safety plan, and least restrictive options. Will the individual agree to attend treatment voluntarily? So when the DCR goes in to assess, they introduce themselves, let them know who they are and what they're there for. And that there's 3 options to today. And if they're able to understand or participate, then least restriction options are looked at for voluntary or safety plan. The safety plan that can be created, it has to be viable. It has to be able to be tested. It has to have a backup. And the DCR has to have the buy-in to it for it to be a safety plan that's workable. It has to have phone numbers, be able to be contacted, have a second person if you can't contact, have follow-up for treatment, outpatient providers, whatever the need was that brought them to be in front of the DCR. Least restrictive alternatives to detention. When considering whether to utilize alternatives to emergent detention, the DCR assesses whether those alternatives are available reasonably, and if if individual is willing and able to accept those services, and if environmental controls and supports are in place to reasonably ensure the safety of the individual and the community. Voluntary treatment. The lack of a voluntary bed is not grounds for involuntary detention. So if someone's in the ED and they're looking for a bed and can't find a bed, that is not a reason for a social worker to call out for an involuntary detention. Again, that's involving removing someone's rights from them and their right to choice. And if they're able to be oriented and have those rights upheld, then that's the avenue we need to go. No jail or state correctional facility may be considered a less restrictive alternative to detention. Voluntary placement is what we aim for. We aim to work with the individual. We cannot detain based on not a good faith voluntary. Components of the ITA investigation. So when a DCR gets the referral, they're going to look at the referral, what it says. Sometimes a medical packet will come with it. Sometimes it'll just be a referral in the community. They will look and gather as much information and history as they can as they're accepting the referral. They will reach out to credible witnesses, speak to them, make sure the credible witnesses are willing to be put on the petition. Otherwise, the information they're giving cannot go in the petition. They have to be willing to testify. Written documentations and records, copy of mental health directives, guardianship, paperwork, power of attorney. Those have to be able for the DCR to get their hands on, for the DCR to say that there's a mental health directive in place or there is guardianship in place. If the DCR cannot have the paperwork in front of them or their hands, then they have to just keep moving forward because of timelines. They always reach out and do their best to talk to people and make sure if we can get the paperwork, because we want to do what's in the best interest of the client. Crisis plans and treatment plans are always reviewed. Gathering information under RCW 7105.212, considerations of information and record, types of information to gather. So forensic evaluations that are done with or without a recommendation, DCRs usually will have those kept in some document library where they can review whether they've had a past one. Historical behaviors, including history of one or more violent acts. DCR will look back at history. The last 2 years are really pertinent for their documentation and petitions. prior detentions and commitment, risk assessments and/or discharge summaries from the Department of Corrections, crisis plans and mental health advance directives, any other available records that we have. Sometimes we'll have typewritten records, or family will turn in texts on paper. I mean, we review all that. Criminal history records, prior civil commitment, medical records or EDI information. A lot of the times a DCR will work with the social worker to gather more information through care management. Any information collected in a prior evaluation documenting cultural considerations, and just being really aware to speak to the person where they at, and remember, cultural considerations are important. Interviewing witnesses. Interview reasonably available, potentially credible witnesses who may have pertinent information. Family members, landlords, neighbors, others with significant contact. Interview professionals and other treatment providers, including tribal providers. If the evaluation takes place in an emergency room, the DCR must have considered the observation and opinions of an examining emergency room physician, ARNP, or physician's assistant when making the determination regarding detention. This consideration must be in consultation with a professional or a review of their notes. The DCR must document this consultation or the reason for lack of consultation, both in the petition and in case of documentation.
So in determining the presence of behavioral health disorder, this is part of the investigation. We do need to determine if there is a behavioral health disorder causing this imminence, or is there a substance use disorder that's causing imminence for this individual. There doesn't have to be a formal diagnosis. We can make that diagnosis when we're seeing the patient. And so we're going to be looking at what's going on with them and what are the symptoms that we're seeing. We're going to be doing that during the face-to-face evaluation. We're also going to be gathering that information through collateral sources, history, documentation, past diagnosis, treatment, and intervention. We're going to look at how that behavioral health disorder is impacting their functioning today. How is it impacting their cognitive and volitional functioning right now, currently, today, when we're seeing them? We're also going to be using the DSM-5 framework for substance use disorder, and you can look that up under this link. So when we're looking at the presence of a substance use disorder, we do have a few factors that we're looking at. Is this substance being used in like large amounts over a longer period of time? Are they having unsuccessful attempts to cut down or control the use of this substance? We don't want to like detain somebody who's gotten drunk once and they're, having a hard time. We want to look at somebody who has a pattern of substance use disorder, and we want to look and see, are they spending all their time surrounded by the substance or looking for the substance or using the substance? Do they have cravings and a strong desire or urge to use the substance? Has it gotten so bad that they can't stop drinking, or they're going to start having tremors and seizures? Are they continuing to use the substance despite having persistent or recurrent social or interpersonal problems? Like, are they losing their children because they've to child welfare because they've been using substances and can't stop? Are they putting their children in unsafe situations because they're not fully there due to the impacts of the substance? Are they using the substances in situations which are physically hazardous? Like, are they, going to some dangerous place and, not being protective of their own health needs? Is this substance use continuing despite having an awareness or knowledge that this is a recurrent physical or psychological problem? Do they experience tolerance, and do they experience withdrawal? So, some of the things that we look for when we're looking at using substance use disorder as a reason to detain is like, we'll look at the hospital records. Is there a history of them going to the hospital like 10 times in the last month? Are they just going home and sobering up and then returning to use? Is it causing them to be taken to jail for DUIs? Like, all of these things are really important. We want to know like how the impact of the substance use is impacting this person's life in every sphere and aspect. When we're looking at determining imminence, so first we have the part where we're looking, is this a substance use disorder? Is this a mental health condition? We then need to look at imminence. So what is going on right now that puts this person or society in danger? So when we're looking at imminent danger, we want to look at what's happening today, right now, not in the future, not in the past, but what's happening today in the moment that we're seeing them. How are they at risk? Is this as a result of a behavioral health disorder, or is this as a result of a substance use disorder? So, like, there are people who are engaging in criminal conduct and it doesn't have anything to do with a mental health disorder. We're not going to detain them, even if they're putting others in imminent risk. That's like the police are going to handle individuals like that who are just engaging in criminal behavior. We have to make sure that the reason that there's this imminent danger is because of their mental health or because of the substance use. And that's really important. And that can be hard for some of the facilities to understand because they'll say, well, this person is, this teenager is running away from home all the time. This teacher or, this youth is, fighting with their parents, but they have no history of mental health or substance use. Like, we're not going to be able to detain them for that. We want to look at, um, our evaluation. We want to look at their history, interviews of witnesses. We want to look at legally determined criteria that we have in our RCWs. And again, we just want to look at all of the risks that we're seeing currently, imminently today. So when we're looking at danger to self or others, this is sort of the definition that we use in the RCW, um, which is physical harm will be inflicted by an individual upon his or her own person, as evidenced by threats or attempts to commit suicide or inflict physical harm on oneself. It can be physical harm inflicted on another. It could be behaviors that place others at harm's way, or that person has a reasonable fear of sustaining such harm from the individual. This can also include physical harm to the property of others, and it has to be over a certain amount. Can't remember right now what it is, but I think it might be over 1,500. So, like, let's say it's somebody who is flooding the entire apartment floor because they're afraid that there's something stuck in the toilet, so they keep flooding it, and this is because of their mental health. That would be an example of physical harm that could be inflicted by that individual. Have they threatened the physical safety of another and had a history of one or more violent acts? Like, is this somebody that, a person that I saw just last week was threatening to hurt her grandparents because they're old. And does she have a history of threatening them? She did have a history of violent acts towards them. And so that made us take this assessment much more seriously. When we're looking at grave disability, this means that that person is struggling to care for their own basic needs. So we can also detain due to grave disability. It doesn't have to be imminent threat to self or others. We can also do grave disability. Are they not taking care of their own basic needs? Like, are they not eating or drinking? Like, I saw an individual a couple years ago who was in a bed, could not get out of the bed, wasn't eating, wasn't drinking, was going into kidney failure. Um, Due to psychosis. And so we want to look at that. That would be a really clear example of grave disability. So we want to just see, are they unable to engage in their cognitive or volitional control due to their mental illness? And is this leading to them not getting the care for their health or safety? Another example might be somebody with type 1 diabetes who um, is delusional and feels that the medications are being poisoned, so they're not taking them and they're ending up going into comas frequently. We had an individual like that down in Clark County. And so she was so gravely disabled due to her mental illness that she wasn't taking care of her own basic needs. So, one thing that I like to make clear for others when we're talking about the ITA investigative process is during the time of the investigation, that individual is on a hold. They're not detained, they're on a hold. And so basically we have a time frame to investigate and decide if we're going to hold them and look for placement. It's 6 hours if that individual comes in voluntarily to a hospital. It's 12 hours if we're seeing them in the community, 12 hours if the police bring them into the hospital, or 12 hours if we're seeing them at the jail. So we have 12 hours to investigate, and that's for any individual 13 years and older. And during that hold, we make that determination. And they're typically referred by family members, first responders, medical providers, community members. These are all the different areas of people that can request an ITA for an individual. And they need to be arising from concerns regarding their safety, their history and presentation of mental disorder or substance use disorder. Once we decide that we're going to hold them and we look at facilities and we find a facility to take them, then we've detained them. So we're detaining the individual to a facility. And so when a facility has accepted them, they are detained for 120 hours, which is about 5 days. And they can be detained to a secure withdrawal and management stabilization facility, which is called SWIMS, or an evaluation and treatment facility for mental disorders. There are some facilities that are dual credentialed so that they can manage people who are dual diagnoses, who have both a substance use disorder and a mental illness. And they can stay and be treated and stabilized for 120 hours. And then they will have a hearing, after that, not counting, it's going to exclude weekends and holidays. So it's usually about 8 days later that they'll get the hearing. And they have to be released after that initial 120 hours unless the treatment team determines that they're still at risk and petitions the court for commitment.
14-day, 90-day, and 180-day commitment. If the individual does not stabilize within the first 14 days, the facility may petition the court, who may then order a 90-day commitment. Subsequent petitions for continued treatment may be filed in these orders or for a 180-day commitment. An individual may be transitioned to a long-term community bed or a state hospital bed when a 90 or 180-day commitment is ordered. Least restrictive alternatives must include. So least restrictive alternative, like we just spoke about, must have care coordination, intake evaluation with provider, LRA treatment, least restrictive alternatives treatment, psychiatry, and or substance abuse evaluation. Must schedule regular contacts with the treatment services for the duration of the order. Transition plan for end of order, individual crisis plan, consultation about a mental health advance directive. So when someone is on a 90-day, the judge commissioner can order them to do a least restrictive alternative. With this order, there is conditions, criteria that the individual has to meet, and it's about housing, treatment, not doing drugs, not doing things to harm themselves or others. And these are wrote in conditions. So a care coordinator might say, call or send a notice that they broke the conditions. So breaking the conditions is one thing, yes, and that's important. And their treatment provider, care coordinator will work with them on that. It is not until the person shows decompensation actually that a DCR can revoke them, because they have to be able to meet the requirements to go back into an inpatient bed. So least restrictive alternatives is working with the individual, keeping them going forward, setting goals, making sure they're having quality of life, making sure they're stable with housing, food, resources, interventions to help keep them in the community and make the LRA work for them.
Yeah, and it's really used as a step down from those 90-day or 100-day commitments. It's allowing them to go home and return to their community, but with all those supports.
Yes. Assisted outpatient treatment. So assisted outpatient treatment is a form of civil commitment. And the person has to have a behavioral health disorder or a mental health SUD order. And an AOT is looked at as the least restrictive alternative. At least one of the following has to be true. The person is unlikely to survive safely in the community without supervision, and the person's condition is substantially deteriorating. The person is in need of AOT order to prevent a relapse or deterioration that would likely result in grave disability or a likelihood of serious harm to themselves or others. And the person has to have a history of lack of compliance with treatment and their behavioral health disorders. At least twice within 36 months prior to filing has needed hospitalization or forensic or other mental units of a correctional facility. At least twice within the last 36 months prior to needed emergency medical care or hospitalization for behavioral health related medical conditions, including overdose, infected abscesses, sepsis, and other maladies. And it also resulted in one or more violent acts, threats, or attempts to cause serious physical harm. And an AOT application can be done by outpatient providers, and they work with an AOT treatment person with the DCR office and putting together a petition of their own and filing it with the court. And then the court will sign it or ask for more information. And then the person will be given a court date, served and given a court date. And these compliance can go up to 18 months for assisted outpatient treatment. And
There's some alternative ways that DCRs interface with individuals as well. And so we kind of wanted to go over these laws. Sheena's law is an important law. It is a law enforcement referral. So what will happen is, let's say law enforcement is out in the community. They see somebody who is reportedly suicidal. They don't take them to the hospital. They don't feel like they have enough to take them to the hospital, but they want us to follow up with them. They'll have a DCR reach out. So they'll complete their police report and they'll send it over to the DCR office. Then within 24 hours, we have to reach out to the individual to check in on them, to see if they need resources, to see if they need supports. And so that's something that we do. So we regularly do Sheena's Law referrals in all of our agencies. They have to be done within 24 hours and excluding Saturday, Sunday, and holidays. But we definitely have to, try to reach out to that person, try to get a hold of them, and determine whether there's additional mental health intervention that's needed. And there are times when that person might need to be assessed by a DCR, and we might need to consider an ITA. And so we would work with our community agencies and figure out how to get out to see that individual and complete that assessment. We could also send out mobile crisis to see them, to see if how they're doing in their community and if more supports are needed for that individual. Sheena Anderson was the person that this law is actually named after, and she was a 30-year-old mother of two who was murdered by her husband, who was having mental health concerns. And so he was seen by law enforcement. He was taken to the ER and then released from their custody. And then turns out that he ended up taking her life. And so that's how this particular law was created, to prevent situations like that from happening. So anybody who's kind of met law enforcement's criteria for a hold due to suicidal ideation, but officers were unable to locate, would also be part of this. So it just kind of helps make sure that all stones are not left unturned and that we're all communicating with these individuals and helping prevent catastrophes like this. Ricky's Law is another extremely important law that is here in Washington state. And this is the law that actually allowed us to be able to detain for substance use. We used to only be able to detain for mental health. And Ricky and his supporters advocated to have a law created where we were able to detain for substance use disorders. So this is the involuntary commitment law for substance use. The only problem with this can be sometimes there's not enough facilities to detain to. There's not enough substance use or detoxification facility beds. And so often, that can be a deterrent to treatment. Patients like Ricky, he suffered with his own substance use disorder, ended up in emergency rooms, mental health facilities, or even jail cells, and instead of getting substance use treatment. And so that's what they're aiming for with this law, is to help make sure that people are getting treatment for substance use. This was Ricky Clausmeyer Garcia. He is the person that the law was named after. He advocated for support for individuals with mental health and addictions in Washington state. He struggled with substance use disorder. He was hospitalized multiple times. And he ultimately sadly passed away at age 37 in a residential substance use facility in Kirkland. But his legacy lives on. Every time we evaluate somebody with a substance use disorder, he's remembered. So his law, yes?
Oh, I was going to do Joel's law.
Go ahead.
Joel's law, SB 5269, passed in 2015 legislative session. This created a process by which specific individuals, immediate family, guardian, conservators, or federally recognized Indian tribe can directly petition the courts for detention. The RCW describes processes and responsibilities for DCR rights and petition. So when a DCR goes out to evaluate someone, say there's a referral called and the DCR does not make it for 48 hours, family member, guardian can do a Joel's Law petition because the DCR has not been able to do a face-to-face or meet the referral. If a DCR has gone out and evaluated an individual and did not detain, and immediate family, guardian, conservator, tribe feels that they should have detained, they have 10 days at that time to file a Joel's Law petition for the court. In 2013, a 28-year-old named Joel Reuter was killed in a standoff with police while suffering from a mental health disorder. When Joel started showing signs of crisis, his parents tried 48 times to get their son the help he needed. After his death, his family organized and pushed for legislation to prevent such a situation from happening again. Joel's Law was approved by the legislature in 2015. It allows courts to order involuntary commitment if, after reviewing a family member's petition and statement, the court finds that the detention is warranted. The court essentially overrules the designated mental health professional's decision to not commit a family member to a facility. If the court reviews and finds that there is probable cause, an individual can be picked up and brought to a facility. The case then follows the usual procedure for Involuntary Treatment Act. Learning objectives. Describe the civil commitment process in Washington and the role of designated crisis responder. The civil commitment process in Washington says that a DCR must be designated by an agency. They must have certain criteria to go out and do these referrals and risk assessments. The role of the DCR is to go out and assess the risk, make the decision, and either hold or not hold and find placement. It's also providing resources, helping the individual to set goals, helping the individual with coping skills, talking to providers, parents, family, stakeholders that are invested in this person, making sure to identify if there's least restrictive alternatives that we can work with the individual. Detaining is an option. Least restrictive alternatives are better. Every time a person is detained and they come out, they have to restart their lives. They have to get everything in order, money, where they're living, maybe where their animals are. they have to just restart that life. So the most that we can do to help an individual be safe and have quality of life in the community is the best laid plan. We identified elements of assisted outpatient treatment practices in Washington State, and we've looked at and discussed additional routes to civil commitment in Washington, including Joel's law, Sheena's law, and Ricky's law.
So we have a few minutes for questions, and that's all the information we're gonna present today.
Oh, thank you so much, Laura and Dawn. You packed in so much information in that short time. We really appreciate it. As you can imagine, we got several questions, and unfortunately, we won't have time to address all of them today. But for those who did ask questions, just be assured we are going to bank these questions, and hopefully we can pose them in future sessions. One of the questions that came up is, why does the law seem to be upheld or interpreted or implemented differently from county to county within our state?
So if you look at the regulatory codes of Washington, they're there and they're stated in a impactful way. So that a DCR knows what to do. But then you look at the resources in counties. So you go to counties, and every county has different resources, petitions, criteria. They have different court systems that are looking at the criteria and the legal. They have different ideas about what is legal. Some counties will do non-emergent. Some counties won't. Some counties will do emergent. AOT is in some counties. Some counties really believe in the least restrictive alternatives and the LRAs. So it's really dependent on the county, the resources, and the hospitals that you're working in that county, what they are able to do. What least restrictive options are out there in that county, that is really dependent on their resources. Do they have shelters? Do they have drop-in clinics? Do they have walk-in appointments? Some of the rural areas and smaller areas do not have these. So those least restrictive options aren't available. Other areas have abundance of them, and that makes it really different in how the law is upheld. Some areas you will go and you will say that you're down in Cowlitz County and someone gets accepted up in Spokane, and they review the petition and determine that the person doesn't need more than 5 days and comes back to your county, and you're assured that they needed more than that. But again, it's up to the county and the court where they're at in the facility, whether treatment is provided further or not. So all of the DCR, they have a really narrow line, and that is to look at the person in that moment, assess, and make sure that they are safe. Where they go from there, what facility they go in, what county they go in, and the resources available in that area really is dependent on how they come out and what their treatment plan is going to be back in your area.
All right.
Dawn, do you have
We have
anything?
time for just one
No,
more
sounds right.
question.
Okay.
Something that comes up quite a bit is this idea of imminence, and I heard that term in your talk. Can you tell us a little bit about, is imminence a requirement in the law, and how do DCRs evaluate imminence of harm, for example?
Imminence is part of the law. The person does not just have to have a mental health disorder or substance use disorder. There has to be an imminence. There has to be a danger that they're currently in, or a danger that they're putting other people in, or they're gravely disabled, meaning they're not taking care of themselves. They're not taking care of their health issues. They're not able to function in society independently. So those would be the two areas we could detain under. But imminence has to be there. Imminence is the reason we're taking away their rights. We can have people who have chronic long-term mental illnesses, and we're not going to detain all of them. People are allowed to have delusions. People are allowed to be paranoid. That does not mean that we need to detain them. When we're detaining somebody and removing their civil rights, it is because there is some element of danger that we do not feel like they can be safe in the community, or some risk of harm to either themselves or others that we feel they need that structured support of a facility, or they're putting their own life at risk or the risk of, lives of others at risk because they're so gravely disabled that they're not able to manage their own needs. That is why we would be removing their rights. And so that is why imminence is such a key part of this law, or grave disability.
Thank you both, Laura and Dawn, for your excellent talk and responses to questions. I wish we had time to ask you many more questions, but hopefully at the session in June, we'll be able to get more information from you. Just as a last slide, I want to remind audience members that we will be having another lecture in this series coming up on February the 4th. Very excited because it's a panel of persons with lived experience who are going to share some of their insight information. And then also, please feel free to give us some feedback. We really do want to improve this series and future series, so we appreciate any feedback that you can present. With that, I'm going to conclude for today. Again, thank you so much, Laura and Dawn. And for those who participated with us, we hope to see you at future sessions.
Thank you, and we'll
Take
see you
care.
in June.
Thank you so much, everybody.